Yes, Mr. Speck.
My lords, my lady, the final point on the fair dealing defence is the pro-Sebon case and the error that we say the judge fell into in failing to follow its guidance as to identifying what are or may arguably be current events and what activities are, quotes, for the purpose of reporting such things. Can I ask you to take out pro-Sebon? It's in tab 12 of the authorities bundle. This was a case the judge was taken to, but he didn't mention it. Just to give you a bit of context about the case, it's an appeal against a finding of copyright infringement made at a trial. It's a case about...
You've just lost me for a second.
I'm sorry.
Mr. Speck, where have you gone?
I'm taking you to authorities bundle tab 12, so first bundle, tab 12. It's a case called pro-Sebon. It's a decision of this court.
Yep.
It's an appeal. I was just going to tell my lords and my lady a little bit about the facts so you understand what was being debated. It's an appeal against a finding of copyright infringement made at trial. And the case was about a TV programme made by Carlton, which was criticising the culture of checkbook journalism. Back in the days of people finding themselves in unusual circumstances, then finding their way to people like Max Clifford and then into the papers, or in this case a TV programme, being paid for their story. And the Carlton programme included material taken from a German pro-Sebon TV programme that had featured a person who'd become very well known at the time for a pregnancy with 8 babies. I think her name was Allwood. And so the programme was an instance of checkbook journalism, but apart from that, not specifically relevant to Carlton's objective. But it used extracts from the pro-Sebon programme for its programme. Those were the facts. Can we pick it up at page 244 of the bundle? So that's 613 of the report, just around letter C. You see there that the degree to which the challenged use competes with exploitation of copyright by the user is very important. That reflects the fact that most cases actually concern a work that is being or will be commercially exploited, and commercial competition is a well-known factor. Then the passage goes on, the extent of the use is also relevant, but its relevance depends very much on the circumstances. That's just below letter C. There's then the mention of Hubbard and Vosper, where it was contemplated that the quotation of an entire short work may be fair dealing. And that's echoing a point that I've been making earlier. It isn't just a question of how much in the sense of the proportion of the work, because taking all of it even could be fair dealing. Now the judgment then turns to questions of what the requirement of the fair dealing sections in the Act were referring to, where they talk about for the purpose of. It's obviously either reporting current events or criticism or review, because they're the two particular fair dealing provisions. And can I show you a couple of important passages on page 245, if I can? The first is between B and C. We see for the purpose of should be approached in the sense of, in the context of, or as part of an exercise in. And I invite my lords and my ladies to note that. And the second important passage is down at letter G. Both the phrases criticism or review and reporting current events are expressions of wide and indefinite scope, and they should be interpreted liberally. Please also note there was little assistance from comparisons with other expressions such as current affairs or news. So we say current events is broad, to be interpreted liberally and not to be equated with or substituted with the words news or current affairs. And so putting these passages together, what we're talking about when looking to see whether use that is complained of is within this defence. Not necessarily that the defence will succeed, because fairness is obviously the further requirement, but in terms of whether it falls within for the purpose of use for the purpose of reporting current events. It simply has to be in the context of, or as part of an exercise in reporting current events as interpreted liberally. As I've said, of course, it still has to be fair, and that's where requirements as to the amount taken and so on would come in. Now, just finishing the case, the conclusion was that the Carlton programme was made for the purposes of criticism or review of works of checkbook journalism generally. You see that at letter D on page 248, and the appeal was allowed. And that, i.e., the defence was made good in that case. And it's important, this case, in my submission, and perhaps unfortunate that the judge didn't refer to it at all, because it shows the correct approach for current events and what is for the purpose of it is wide. Now, the judge did do, in paragraph 153 of the judgment, was to distill from our paragraph 37 of the defence 5 topics as putative current events. And can I actually take you to the pleading to show you what we pleaded? And that's tab 21 of CB2 towards the front of that volume, and it's page 368. You've had it out a little bit earlier in my submissions where I was contrasting the grounds where I was contrasting that paragraph with the one for free speech. Sorry, it's 363, the page, not 368. And can you see just below the top hole, one of the things we identify is this: by mid-February 2019, the existence of the letter and a description of the contents of the letter and the claimant's version of her conduct towards her father had very recently entered the public domain and was being reported widely. Now, that doesn't make its way into the judge's list, at least as not so framed. What we do have in his paragraph is his subparagraph B in 153, which is the People article disclosing the existence of the letter and giving a description. But the broader description as being the contents of the letter and the claimant's version of her conduct towards her father is not there. We say it was plainly raised in the pleading and can properly be considered well arguable as a current event. As the pleading alleges, those things were being widely reported. We also say the judge didn't follow the approach in pro siebem when he took too narrow a view of the more general item identified in the judge's paragraph A, and that's the claimant's conduct towards and estrangement with her father. That was also being widely reported. As we've seen, current events doesn't mean it has to be current affairs. It's to be understood liberally. And the point that I'd make to my lords and my ladies is if it be shown at trial that a wide variety of media outlets are reporting something, it's obviously well arguable that it may be properly understood as a current event in the sense used in this fair dealing provision. Moreover, whether or not I'm correct about those two criticisms that I make as to the judge's view as to what qualifies, the articles do report the items that the judge accepted are arguably current events. For instance, Mr. Markle's reaction to and view of the People article, his dispute with the version of the claimant's conduct towards him, and his contradiction of and dispute with the version of her conduct towards him. That includes, if I may say so, also the handwriting article, which follows the modern approach of online reporting, where the same basic story is put online more than once in multiple online versions with additional angles or focus added. That article still does those things. The use in all of the articles is in the context of reporting those matters. And what the judge is really doing by saying it's not for those purposes, this is his paragraph 155 and 156 of his judgment, is aligning the question of fairness and what is with the question of what is in the context of reporting current events. one sees quite clearly he thinks too much was taken to be legitimately for that purpose. And so we see at the end of para 155 of the judgment where the sentiment is that what was reproduced wasn't legitimate reporting. Basically, his analysis was too much was taken. It's the same analysis as the privacy-free speech balance. And so he says in paragraph 156, the use was for the purpose of reporting the contents of the letter, which according to him is not a current event. As I've already explained, we disagree, and I've submitted that its existence and description had recently entered the public domain and was a current event and being reported on. But either way, that's not an answer to the submission that it was in the context of, or part of, an exercise in reporting the things the judge accepted were common current events. Whether it went too far, in the sense of took too much, is a question for fairness. And he's elided those two together. So that's our final point on fair dealing. The judge wrongly failed to follow the pro-Sebum approach and correctly assess whether the use was in accordance with its guidance and for the purpose of reporting current events should be approached liberally in the way that I've explained. Now that is the end of my note.
Sorry, can you just explain how that fits in with what the judge says at 156? He seems to be saying that only part of, there is part of the reproduction that links in with the current events issue, but only part of it.
Yeah.
And the rest doesn't.
Exactly. And
but what's wrong with that?
Well, my point is, that's a question of fairness. What his view really is you've taken too much to be fairly doing it for that. And what's undoubtedly right.
The bits, isn't he saying also that the bits that you've taken don't relate to that topic, as it were? Putting it crudely.
Well, he's basically saying you've gone too far to be doing for legitimate reporting. And what we say is that the correct approach to section 30 is that are you doing it in the context of an exercise in reporting current events as construed liberally? That article is doing that. We are doing it in the context of that. I totally accept that there may be a further question that have you taken too much, gone too far than is appropriate? But that, in my submission, is a question of fairness. It doesn't mean you're not doing it in the context of reporting the current events that he identified. And so I just say that the judge is eliding those two concepts incorrectly in my submission. The articles do report the matters that he's identified. So it is in the context of that. He should have been addressing quantity under the heading fairness.
Yeah.
I think, unless anybody around this, those are my submissions, unless my lord or my lady has any further questions.
Thank you, Mr. Speck. Yes, Mr. Rushbrook.
My lords, my lady. My learned friend, Mr. Caldicott, devoted a considerable amount of his submissions to the proposition that this is a case that proliferates with triable issues. I don't think the court will be surprised to hear me say that, from our point of view, this is actually a very straightforward case, which the defendant has made inordinately complicated. Not quite as contentious, evidentially, I suspect, as the Prince of Wales case, but certainly judging by the amount of the core bundle that is devoted to the pleadings, it does bristle on its face with issues of fact. The case does raise an important question about the right to control personal and private information in the form of a letter. Various facets of that are notable. One, that this is a letter, it's correspondence. And correspondence is separately mentioned as deserving of protection under Article 8. But it's correspondence within a family that relates to the personal life of the claimant and the feelings of the claimant. And the fact that she describes the letter in the terms that she does, namely an account of what transpired, which is perhaps not doing it justice, makes it nonetheless personal and private for that. So the starting point, and all cases have to have a starting point, is that the claimant's Article 8 rights are on the face of it triply engaged. It's her right to private life, to family life, and correspondence. And for what it's worth, the European Court of Human Rights has endorsed the proposition that there is something significant in the fact that correspondence is not qualified by private. In other words, any correspondence, in principle, is capable of engaging the Article 8 right. That probably doesn't matter here because there can be no doubt that the subject of this letter made it highly personal. So we adhere to the way it was put in front of the learned judge below, which is that the case does raise a question which doesn't appear to have been addressed before, certainly in the modern law of privacy, about who has the right of first publication of a private letter. Bearing in mind this was a letter of which extensive contents, around about half of it, it's a long letter, were first published by the defendant without the consent of the claimant. That's obviously an important Murray factor, or even notification. It was the defendant who first brought the contents of the letter into the public domain. And picking up on something that my Lord the Master of the Rolls...
Is that right?
Yes.
The defendant first brought the contents, you mean the actual words?
Indeed. And my Lord...
Not the fact.
Quite so. And there is a very material distinction.
Yeah.
For the reasons that my learned friend quoted from our skeleton argument. A letter is in some ways analogous to a photograph. In fact, in some ways it's more potentially revealing or intrusive than a photograph because of what it says about, so to speak, the inner life of the writer of the letter. And so we don't shrink from the proposition that if domestic law is to do its job properly and to be convention compliant, a newspaper that brings into the public domain extensively the contents of a private letter needs to show particularly good reasons to justify that. Now, my lords and my lady, I will come back to the stage one point, but for present purposes, if you will kindly assume that that stage has been passed in this case, as we say it plainly has, the key issue which the judge had to address, and I hope this is a helpful way of putting it, was given the claimant's reasonable expectation of privacy in relation to the contents of the letter. Note contents, not the fact of it, nor even a description of its contents, which is the way it is pleaded by the defence, a description of its contents. Did the claimant, directly or indirectly, put anything into the public domain, viz. Through People magazine, which arguably waived or compromised those privacy rights, such as to justify the defendant in publishing those extensive extracts of the letter.
Is that really the question?
That was the question.
Where does the waiver question come from?
It's
As a matter of law.
well, perhaps it's not helpful as a shorthand for were her rights extinguished or outweighed.
Well, I mean, it's all about outweighed.
Yes.
I mean, it's all about the balancing exercise between the Article 8 and Article 10 rights and the two free speech rights on the other side are those of Thomas Markle to reply to what had been put in the People article, and the question of what was put into the public domain, which is inherent in your formulation as well.
Yes, but
I mean, it's not that difficult, as you rightly said. It's a balancing exercise, and the question is, did the judge do it effectively, or was he able to do it, bearing in mind the evidential situation on a summary judgment case?
this is by way of headline because I'll come back to it. That does raise the question of what it is for a defendant to show, as it were, on the pleadings or at a summary judgment application.
Well, does it? I mean, I thought we'd had legions of cases which told us what had to be established in order to refuse summary judgment.
Yes, but the question which has some novelty here is in the context of a private letter, given the strong starting point, what arguably constitutes a viable justification for the extensive publication of the extracts from the letter. And where I do strongly differ from a learned friend is on the question of the subjective belief of Mr. Markle.
What do you say about the subjective belief of Mr. Markle?
It's irrelevant at stage 1 or stage 2.
It's irrelevant that he believes he's being traduced.
Yes, it's for the court to decide objectively at both stages what is proportionate and germane, and also in accordance with the ethics of journalism, which is a European court phrase, but it has its analogue in the IPSO code, which I
Sorry, what word?
The ethics of journalism.
Right.
And so, I mean, perhaps the most obvious answer to the contention that Mr. Markle's belief is something that needs to be tried out in this privacy claim.
Is it a belief that I didn't hear Mr. Caldecott say that his belief needed to be tried out?
The honesty of his belief.
I didn't hear that either. It's not a question of Mr. Markle's honesty. It's a question of where the balance of freedom of speech lies and whether he has a right to reply through the newspaper to the allegations in the People. And Mr. Caldecott says the allegations in the People were far more extensive than the judge understood them, and he didn't record them accurately, and that when taken for what they were, Mr. Markle, because he was saying he was to put it loosely, they were saying he was a bad person, and he had a right to some kind of right, which had to be balanced, to say he wasn't. And where the truth lies, perhaps only can be ascertained at trial.
Lord, I respectfully agree with the first part, but not the second.
Yeah, well, I know you don't agree with the second, but I mean, that's what Mr. Caldecott says.
Yes, that's what he says, and he relies for that purpose on an alien concept, which is the concept of a species of qualified privilege in libel, namely reply to attack.
Well, that's a terribly interesting question as to whether we lift those authorities into the law of privacy. But I wonder whether it really matters, because plainly one factor in the balancing exercise concerning freedom of speech in a privacy case is the response that a person traduced in public may wish to make. And whether you apply exactly the same rules as one might have applied in a long time ago in defamation feels to me like a similar question to how many angels can stand on the point of a needle. We are only concerned in this case with whether or not there were facts which ought to have been tried out before the judge took a final view. I mean, you push at an open door, Mr. Rushbrook, if you want to tell me that the judge may well have been right. Of course, he may well. And the question only is whether he was right to decide those questions without a full trial.
Yes. And relevant to that question is what is it that he should have been trying? And I think in fairness to our argument, the proposition was urged on you by Mr. Caldicott that Mr. Markle honestly believed both that he had a right to reply in those terms.
Well, of course he would say that.
Yes, and moreover, that evidence as to the impact on his reputation would be relevant at trial. That's completely irrelevant. Indeed, in libel cases, it's for the judge to decide the impact, certainly as a threshold question.
Well, I mean, when you cross-examine witnesses, you probably do focus on whether they honestly think things, but ultimately what one has to decide is the rather difficult balancing exercise between the Article 8 rights to which you've alluded and the Article 10 rights to which Mr. Caldicott alluded.
Yes.
That depends on the facts.
My Lord, up to a point, because as we say, the question of what objectively could amount to a justification, if I can use that word in the sort of Campbell sense, is one for the judge to assess. And in an appropriate case, if he is in as good a position as we say he was, because it's an objective test, at summary judgment stage, to form the view that there is no real prospect of the balance coming down in favour of the defendant, weighing in those rights, then he is entitled, and in our submission he's bound to give judgment for the claimant, partly because that is the appropriate way of giving effect to her Article 8 rights. A trial in a case like this would certainly, if conducted the way the defendant wanted to, be a further intrusive process. Of course, if the defendant is right and it gets its trial, then too bad. But if we're right that there is no need for a trial, it is an extra reason, it's a good reason, as a matter of the practice of privacy law, nothing else, that the court, in an appropriate case, will say, no, it doesn't need to go to trial, and it shouldn't go to trial. My Lord is right that there are relatively few summary judgment applications in privacy cases, but as Mr. White said, I think, in the court below, everything was new once. And we are still, to an extent, in relatively new territory.
But that's the problem, as I see it, is not that it's new, because there will be clear cases, and that's absolutely fine. And we don't close our minds to anything in these courts, or at least I try not to. The question is where you have a balancing exercise, which has to be undertaken on the basis of hotly contested facts, and I'm not talking about motivations, I'm talking about real facts. What did X say to Y in a text message or a series of text messages? Was that true? If it was not true, does it entitle X to say in answer to Y something that was true or not? Now, all that does have to be balanced on the basis of facts, and it appears that there were a number of facts which the judge was not able to take into account because he didn't know them, at least. And that sort of rings a little bit of alarm bells with me, because I say, well, is this can it be a proper balancing exercise if the facts are coming out as rapidly as they seem to be in this case?
Well, I'm going to try to assuage those concerns, because where we say that the judge in this case correctly drew the line was between facts which did need to be tried and those which didn't. And by saying need to be tried, I mean could be relevant to the outcome. And what he did for the purpose of this exercise is he assumed what we said were all relevant facts in favour of the defendant. And the judgment is replete with examples of that, which I will take you to. What he doesn't or didn't need to try was the he said, she said dispute about the text messages. For example, because they are not, as we submit, logically capable of affecting the outcome of the balancing process.
Can I ask you this, because this concerns me? If it is true that the one of the claimant or Mr. Markle had ignored the other, right, at a particular period, an important period in their lives, and a newspaper article says one side, and the other person wishes to produce evidence publicly to say that's not true, it's the other, surely that is relevant?
My Lord, no, with respect.
Not relevant?
No, because...
Even if it's perfectly clear that the newspaper article is wrong on the text messages and the circumstances recorded in a letter, not relevant to the question of whether the letter is a freedom of speech and the letter is outweighed.
No, because what one has to look at is what the article published from the letter, and then against that background assess the extent to which arguably the People article upon which the defendant hangs its case, nearly all of its case, to what extent could the defendant's deployment of the text, of the contents of the letter, be a justifiable correction of the record is the phrase I'll use, because that's more, I think, it's more orthodox, because it's the strand of privacy law that people tend to talk of, correcting the record. That is an aspect of public interest, and it's the aspect that the defendant...
Can you make that submission again so I can write it down, about when it is that one may take into account, it's only a question of taking into account the correction of the record?
The defendant, as we say it's required to, seeks to justify its publication by reference to people. People is the pretext, and I don't mean that majority. On the face of the articles, it's the pretext for publishing the letter. What the judge had to do was to look at the People article and what it said, comparing that both with the text of the letter and what the defendant published from the letter, reach a view as to whether what the defendant published or deployed was arguably a justifiable interference with those privacy rights, the rights that inhere in the private information. And if the judge does the right job, which we say he did in this case, he actually only needs to look at those three documents. The outer limits, one could perhaps refer to the book as well, and I'll say a little bit about that later. But if the defendant sails under the flag of, well, the People article was misleading, I don't need to say it was an attack, let's just say it was misleading. It includes what the defendant says was an attack. And we were entitled to correct the record, which is what they say. What then has to happen is a very close focus on what the letter said and whether the publication of its extracts was capable of serving the justification that the defendant relies on, namely that the People article required correction. And the judge actually reached three cumulative reasons for saying that the defendant's deployment of the letter was indisputably excessive. One, it was disproportionate, excessive in terms of quantity. It was clearly more than could be reasonably necessary, judged objectively, to serve the purpose for which it was ostensibly done. Two, it wasn't germane to the attack in the People, or the factual errors in the People. And he's right about that for reasons that I will come to. And there's a third reason which your lordships and your ladyship have not heard anything about, and it does feature in his, I think, two parts of his judgment, which was that it was precipitate of the defendant to publish those extensive extracts in the circumstances that it did. Now, why is that relevant? Well, our case, as it happens factually, and the court will have seen our pleaded denials and the references to it in the judgment, is that what the friend, I think she's called a long-time friend in the People article, said about the letter in that interview, which was a 24 or 25 word passing reference, was not authorised by her. Indeed, she said she was upset when she found out about it. That the judge was prepared to assume in the defendant's favour that despite that denial, she nevertheless had somehow authorised that characterisation or description of the contents, to use the defendant's phrase, of the letter in People. But that's not the end of the inquiry when it comes to public interest. Because as he rightly pointed out, accepting a submission we made below, for all the defendant knew, the claimant was right about this. She didn't authorise it. And one thing that is established, well established, in the ethics of journalism as a matter of domestic law, it's absolutely rule number one in a newspaper lawyer's office, is you've got to go to the subject of an article of this kind, whether it's going to invade privacy or libel somebody, and put to them the story that you're proposing to publish. And the judge is absolutely right. This, if nothing else would have worked, this was in itself a killer point, in saying the defendant had no right to assume that Mr. Markle was correct, or its own assumption was correct, and that it was authorised by the claimant. It's pretty obvious, although perhaps it doesn't matter, that they didn't go to her because they didn't want to be met with an injunction application. You don't have to make a finding about that. But there are consequences for a newspaper publisher that doesn't go to the subject of the story and say, in this case, Mr. Markle's upset about what your friend has said about him in People. What do you say about it? He's given us your letter and we're proposing to publish it. On our case, the answer would have come back, don't you dare publish that letter. It's a private letter. And by the way, what the long-time friend is quoted as saying in People is wrong. We agree. She didn't write it to repair the relationship. That's an inaccurate characterization. It's one of the few things that is common ground in this case.
I mean, you concentrate on that, but as you say, that is common ground. And I wonder why you don't, well, I'm sure you will, come to the points that Mr. Caldecott made, which the judge did not recite when he set out what the People article said, and did not deal with, and just dealt with in a global fashion, as saying there was nothing else that mattered. But of course, it may be said, or was said by Mr. Caldecott, that it does matter that it was said, and I can't remember the precise words, I'm afraid, that they hadn't, the allegations were being traded about who'd not contacted who and who treated who cruelly and all that stuff. I think there were 3 specific points Mr. Caldecott made that weren't in the judge's summary or dealt with.
Yes, the reason it was, I will come on to why that was an unfair criticism, but I don't want it to be underestimated, the importance of the failure to contact, because that is absolutely...
No, I get that, but of course it wouldn't, I mean, that may be an overweening point if it's right.
It is.
But nonetheless, I do think you have to deal with the 3 allegations, which are that Mr. Markle had cruelly cold-shouldered the Duchess in the pre-wedding period. Mr. Markle had lied in alleging that the Duchess had shut him out after the wedding, and the Duchess was always taking care of her father with incredible generosity. I think those are the
yes,
things.
We have, I think, a note of them, so I may want to refine what I say. But the short answer, my lord, is that none of the contents of the letter were capable of supporting Mr. Markle's case on these alleged inaccuracies. That is the, to be fair to the judge, there is a painstaking analysis of what the inaccuracies about the letter were in the People article. And he rightly reached the view that it was overstated by the defendant, and that the material inaccuracy...
So what was overstated?
The degree of inaccuracy of what the People article said about the letter.
Mr. Rushbrook, forgive me for derailing your train of thought. Can I go back to your starting point? Tell me if you're coming to this later, in which case it's fine, but it's something that's bugging me. You told us, you referred us to the 3 elements of Article 8, private life, family life, correspondence. You said all these are engaged here. You said that a letter is more private even than a photo, and so you said a newspaper that brings the contents of a private letter between family members into the public domain has to show a very good case to justify it. And you said, as able advocates do, you said this as though it was a self-evident proposition. My question is, does it apply irrespective of how the newspaper got the letter? And in particular, is it relevant here that it was the recipient of the letter who gave it to the newspaper?
My answer to that, my lord, would be it would be even worse if the defendant had got it from someone who had been bribed in the courier's company. I think my lord actually put that to Mr. Caldecott.
Yes.
That would certainly taint the conscience of the defendant, and that would be one of the things that would also go into the Murray mix as strengthening or certainly corroborating the Article 8 right. But, of course, we don't actually know how the defendant came by letter. We know what we're told. But assuming for present purposes that Mr. Markle happily volunteered the contents of the letter, a copy of the letter, even the original, to the defendant, it doesn't, we say, rescue the defendant from its obligation to behave in accordance with the ethics of journalism and proportionately, and to deploy those contents in a way which is logically germane. Or putting it another way, which accords with its stated purpose. The fundamental problem in our submission with the defendants correcting the record defence is that they're sailing under a false flag. And this is approaching an answer to my Lord's question, Master of the Rolls. That when one looks at what is said in the People article about the letter, and yes, it does have other statements in it as well, which Mr. Caldecott has very skillfully woven into his case. But there is a fundamental logical disconnect between the way in which the defendant deploys the contents of the letter and the stated purpose, for this reason, that the letter doesn't rebut the criticisms.
But that's what I was going to ask you about.
Yes.
It of course, doesn't rebut them all clearly and square on, but it does address the three, in some measure, the three criticisms Mr. Caldecott relied upon from the People article.
But Lord, here's the important bit: in ways which actually don't support Mr. Markle,
Well,
they actually undermine him.
Well,
that's the problem.
that is a question. I mean, you're right and wrong. Unfortunately, both sides in this case do not have a beautiful set of neatly tailored facts which mesh perfectly with their own case, or mesh so as to destroy the other side's case. The fact is, it's colourable. It bears upon it. And if it bears upon it, then surely that engages the balancing exercise, which also means that the balancing exercise is better conducted when you've got facts. I mean, that's the point that I think Mr. Caldecott would...
Yes, well, Lord, I understand the point, but the devil is in the detail. We'd better have a look at... Can we have a look at the letter and the People article? So we're starting from the...
Before we... forgive me, so I don't have to keep coming back to this. The involvement of the recipient of the letter. Are you saying that there is a general proposition that the recipient of a private family letter,
Yes.
daughter to father, the father is committing a breach of the daughter's legal rights if he shows the letter to a newspaper or to anyone outside the family?
Well, of course, it will depend on the facts.
Yes.
And whether or not the defendant can bring itself... I mean, there's two questions. Is the father liable and is the
Yes.
newspaper liable?
Well, is the father liable?
The court has had to address this issue. McKennitt and Ash is actually probably the best example.
But Ms. Ash wasn't Verena McKennett's father.
No, she was a
friend.
trusted confidant and
Yeah.
friend. But the...
Focus on family letters.
My Lord, my answer to the question would be, I'm not sure if that specific factual scenario has arisen, but my answer would be, yes, under the modern law of privacy, just because two people, even if they are family members, are privy to, it doesn't even have to be a letter, it could be a secret of some kind, it does not follow that either of them is free to disclose the contents of that information or that secret to a third party. And in fact, Stevens and Avery is probably the starting point for that doctrine. And the answer which the law provides is that if a party is privy to a relationship of that kind, wants to exercise their Article 10 or indeed other rights, then the way in which those rights are protected has to be crafted in a way which properly protects the rights of the owner of the private information.
But does it not matter what the information is? So if it is information about the claimant, so that if the claimant writes to her father saying about her medical condition herself, private information, obviously private information, I quite understand your submission. But if the claimant writes to the defendant father, I'm sorry, I'm assuming the father's a party, but for the purposes of my Lord's example, writes to the father and says, you are a bad person, right, for the following 63 reasons, is that personal information of the daughter, or is that really personal information of the father, to which he's fully entitled to say, not only, I guess, suspect, are you writing this in private letters to me, but you're telling all your friends as well that you think I'm a bad person, and I want to rebut it in some way. Now, it wouldn't normally be a national or international newspaper in a normal father-daughter situation. But I think the input of my Lord's question is, surely when you receive a bad letter from, if you're the father, I'm sorry, I identify with fathers rather than daughters. If you're the father rather than the daughter, you receive a letter from your daughter saying you're a bad person, surely that's information that is private to you.
No, because it may be shared information.
Right.
If it conveys, embodies, or discloses the writer's feelings, whether about the father, the mother, or anybody else.
Yes.
The fact that the feelings may be about the recipient of the letter doesn't reduce or extinguish the claimant's privacy rights in relation to that information. So if there is a clash such that the father wants to divulge the daughter's feelings, we are in classic modern law of privacy territory, and the court has to apply the test of what is proportionate to the alleged right or need on the part of the recipient.
Comes back to a sort of fairly fundamental Article 8 point, which comes from mostly from the Strasbourg jurisprudence, which is the autonomy of the individual and the need of an individual to be able to interact with other individuals in a way that protects their autonomy about what they do and how they do it without interference. So that's the source of this.
Lady, I quite agree, and Roddy, which is cited below and is referred to in the judgment, I think encapsulates the principle.
I didn't understand Mr. Caldecott to challenge that as a premise when he has other reasons for saying that in this particular case, notwithstanding that position, there are strong Article 10 and Article 8 rights, which, when one conducts a parallel analysis, override that position. That's a different point.
That is the difference between us. And Ms. Justice Mumby in Roddy is quite clear that the Article 8 right embraces the right of control over one's personal information. And this is stating no more than what emerges for the first time in Campbell. And that right of control includes the right whether or not to disclose personal information, to whom to disclose it, when to disclose it, and how to disclose it.
Applying this to a daughter-father letter. Suppose royal family isn't involved, just a daughter-father letter. And the letter discloses private information, the daughter's feelings, what she thinks of the father, and so on. If you're right, then the Article 8 rights of the daughter mean that if the father gives notice that he intends to show this to the media, the daughter could get an injunction prohibiting him from doing so. So returning to the present case, if the claimant had had notice, she could have applied for and got an injunction prohibiting her father, at least in this jurisdiction, from disclosing it to anyone, otherwise he would be sent to prison.
From disclosing to the media?
To the media.
That, my lord, that is a very important part of the proposition. Because, again, it's part of the overall proportionality analysis. It matters not just what you disclose, how much of what you disclose, but to whom you disclose it.
Yes.
And to disclose it to a mass media newspaper is something that had I been instructed to go down and get an injunction on the facts of this case and not got one, I would have been failing in my job. Let me put it that way.
Coming back to the question of shared information.
Yes.
Ultimately, this may not matter, because the truth is, nobody is saying there is no privacy in this letter. The extent of the privacy is a question for the balancing exercise, and it's only if the judge and you are right that the factors that Mr. Caldecott said should be taken into account and were not are relevant that you would accept the appeal succeeds. If you're right and the judge is right that they are irrelevant, then the appeal inevitably fails.
Yes.
And so we don't have to get in, like many of the greater reaches of this case, we actually don't need to decide that interesting question, though I agree with my lord, it is an interesting question. But it doesn't arise here because everybody accepts this is a private letter, in some respects, at the very least.
In case it's helpful to my lord, the judge actually did deal in some detail with the question of whether or not it was shared personal information between the claimant and the father. And in my respectful submission, his analysis was absolutely right.
Which paragraph?
And this is 76 1, and down to 2 and 3, and then 4 has a reference to McKennitt. And my Lord Justice Bean's question is to some extent addressed in 3, the shared experience point. So it's not, I think I need to say, Lord, this is not a new or a difficult question. The courts are used to grappling with it. On the facts of this case, as you say, there is no dispute even between my learned friend and me that the letter was to some extent private and personal to the claimant. But he's entirely right, we submit, to say at the bottom of page 142, it was in short a personal private letter. The majority of what was published was about the claimant's own behaviour, her feelings of anguish about her father's behaviour as she saw it, and the resulting rift between them. These are inherently private and personal matters. He then goes on to address the question of to what extent the father might have claimed ownership of the private information, and he largely rejects that proposition. Again, he's right to do so because it's the claimant's own account. One of the benefits, if it can be put this way, of a modern law of privacy is that we don't allow a free-fall where people are enabled to put private letters, which may well have mixed ownership of private information, into the pages of the Mail on Sunday, and then force them to argue it out about who's right, who's wrong, who owns how much information, and whose right should prevail. I mean, that is, with respect to the learned friend, that is what the law is there to prevent.
So you place some reliance on the fact, really, so my Lord's question was fortuitous, because you place some reliance on the fact that had you gone down to court to get an injunction, you would have got it.
Yes.
And I mean, that may not be in any way conclusive, because you only have to show a good arguable case, not or maybe a bit more for a privacy injunction, but you don't have to show you're bound to win.
We have to show that we are likely to win.
Likely to win, but you don't have to show you're bound to win, but it gets you some way if you're right.
My Lord, absolutely, it would not be surprising if the court had not, or the judge below had not, at least privately speculated as to why the defendant didn't notify us of what they were proposing to do.
I mean, the likely to win, I'm sorry, Mr. Rushford, the likely to win is Section 12 is your
correct.
problem.
Exactly right. Section 12.
Injunction, yes.
It's a higher test than cyanamide.
Yes.
And it involves a sliding scale, so likely doesn't have to be more likely than not if the information is particularly prone to damage or sensitive. But that's the broad scheme of it, and I'd be content with more likely than not for present purposes. But, my Lord, can I also be clear, in case Mr. Caldecott jumps down my throat on this? We're not saying that the court needs to find that we would have gotten an injunction, and we're not saying that the court needs to find that we would definitely have been right about my underlying factual proposition, that even the claimant didn't want this in people. But one thing is for sure, is that that very question would have been crystallised in the injunction application. So we would have put in our evidence to say, hold on a minute, this is a private letter. You've got no business publishing it. The defendant comes back and says, look at the people interview. You've mischaracterised the purpose of the letter. To which we say, actually, you're correct that it is mischaracterised, but we did not authorise it. And once that has been said, and the learned friend accepted that it could have been corrected, but seeks to criticise us for not doing so. Once that had, as it were, crystallised in the lists at the injunction stage, the entire pretext for this article would have fallen away.
As it was in the summary judgment case, which we're dealing with, the judge, you're saying the judge assumed, for the sake of argument, what he had to, that the defendant's case in relation to the claimant's responsibility for what emerged in the people was a good one.
He did.
And that's the starting point. Because there is another question, which is, in reply to attack cases, in defamation, it has to be established that you're responding to an attack by the person who attacked you.
Exactly. And all of that we were
sort of fundamental.
All of that we were deprived of the opportunity of putting before the court.
And you say, you say, I think, that we should assume that was done deliberately, because otherwise it wouldn't have happened.
I do say that, and if my Lord is understandably reluctant to go so far,
well,
I understand.
Not in a cynical way, but it must have been a factor. I mean, these are professional people who understand what's going on.
And my Lord, I don't shrink from this. It is absolutely lesson one. It's mother's milk to the nightwear. You put the story to the subject.
What did the judge say about the deliberate nature of it? The injunction. Did he say anything?
He didn't. He rightly held back from saying, well, I can't accept as a fact that that's what would have emerged, but he did accept, and this is the important bit, that it might have emerged, and that's the reason for his precipitate.
Which paragraph? Because you told us it was very important, but then I don't think.
Yes, it's It doesn't immediately leap out the page to someone reading the judgment with fresh eyes, but if the
So he used the word precipitate in 120.
120, yes, my Lord's word search is better than mine. At 120, he tees up the point with precipitate. But he then addresses it full on at 1252 by saying, I don't consider it was necessary or proportionate for Mr. Markle and the defendant to pursue this legitimate objective in the way that they did, by publishing long and sensational articles revealing and commenting on extensive extracts from the letter, and here's the important bit, without first approaching the claimant. It is clear that neither Mr. Markle nor the defendant knew whether or not the People article had the claimant's blessing. For all they knew, this publication was, as the claimant says it was, an unauthorised step. At all events, adopting a proportionate approach, the logical first step should have been an attempt to establish the facts and to see whether the inaccuracy might be corrected by the people responsible for publishing it. So all the jeopardy of the assumption turning out to be incorrect, all the damage in terms of invasion, falls on us. And we say that is not convention compliant when it comes to Article 8 rights. And my Lord, Lord Justice Warby was absolutely right to include that in his, it's really a trilogy of factors, not proportionate, it's not germane, and in any event, it was precipitate.
He referred to the code at one point,
yes.
Didn't he, the Ipsos code? I can find it.
Well, my Lord, you're quite right, if I may say so, that he did refer to it, and this does bear upon the what one might call the burden of proof point, which I will come on to. But in Campbell, if my lords and my lady have bundle 1, Campbell includes in Baroness Hale's speech the relevant extract from the Ipso Code at 159. Oh yes, thank you. And does my Lord, I mean, there's two aspects of the code that are relevant for these purposes. One is the without consent point, which might be thought to be obvious, but it is built into the code. The public interest expressly includes preventing the public from being misled by some statement or action of an individual organisation, and that was slap bang the window through which the defendant sought to go. But does my Lord see that the architecture of the code is that you start off with a, if I can call this a non-legal presumption at least, that if you are intruding into somebody's private life without their consent, you've got to be expected to justify that. And when one looks further down at the language on exceptions, public interest exceptions, it's where they can be demonstrated to be in the public interest. Who has to do the demonstrating? Well, it's the editor, speaking through his or her lawyers. So that is why, it's one of the reasons why, as it happens, Malone and Friends' criticism of, I think it was paragraph 36 of the judgment, was unfair, insofar as it is said that the defendant didn't have to show anything. If that's Malone and Friends' point, he's wrong. Where you've got private information being disclosed by an IPSO subscriber, without consent, it's for the defendant to justify. But having said that, this is not a case, when one looks at the judgment, which the judge actually decided on the burden of proof anyway. It's a bit of a non-point for the purposes of this case, because it's quite clear when one looks, I'll come on to this on the question of the so-called errors of law. But he conducted the balancing exercise and the parallel analysis according to his direction at paragraph 35. Sorry, I'm so sorry, 31. It was my submission of 35 that he recited about the defendant failing to discharge the burden. But at 31, what Mr. Caldecott, even the learned friend, accepted yesterday was that 31 is an unexceptionable, it's an entirely Campbell compliant
Correct.
direction as to what the judge had to do. And with great respect to my learned friend, the idea that by the time he got to carrying out the analysis that he sets out in writing at paragraphs 103 and following, by the time he got to that point, he'd forgotten about what he directed himself to do, is frankly totally unrealistic.
I think on this point he relies on the interposition of the word necessary as well as proportionate.
Yes, and I will have a bit more to say on that, because without going too far ahead, if one looks at the context in which the word necessary is used, it's clear that he's actually using it in the Campbell sense that Baroness Hale and Lord Carswell use it, in other words, as a proxy for justified, or as an alternate for justified. But there is another point which struck us as quite remarkable, which is that it's the defendant's own pleaded case, by way of justification, that it was necessary. And he recites that at paragraph 117, when he sets out paragraph 15.13. Halfway down that citation, he quotes from the defence, "It was necessary, proper, and in the public interest to publish the true and full story concerning the letter and the response to it, including Mr. Markle's account of events. This was necessary for the sake of truth, fairness, and Mr. Markle's reputation." It's a harsh thing to criticise the judge when he then comes on to reject, essentially, that pleaded defence of necessary, to say that he's misdirected himself at law.
Can I ask you a question? Is it possible for an infringement of privacy to be categorically such an infringement at an early stage, before proper inquiries and journalistic practice has been undertaken by a newspaper, which might not, at a later stage, when further material had been ascertained by that journalistic outlet, which might justify the disclosure that wouldn't have been justified before? In other words, could you get summary judgment for the publication 4 days after the People article, in the circumstances you very carefully explained, but not get summary judgment if further hoops had gone through in relation to the same disclosure, or a very similar disclosure, 6 weeks later, say? because you need to understand the thing as a whole.
Yes.
Because otherwise you don't properly do the balancing exercise the judge did.
And the judge was meticulous in his assessment of what it was in each of the unfairnesses or inaccuracies in the People article that the extracts from the letter in the articles were capable of rebutting on behalf of Mr. Markle. And he came to the entirely correct conclusion that nothing that was published from the letters actually was capable logically of doing that. And the obvious reason...
And you say that's why Mr. Caldecott is forced to go to the furthest reaches of this case by saying, well, actually in the People article there were these three specific, callous, whatever the words are, which he didn't specifically address, but you say that doesn't address the main point.
Yes, it doesn't work to say Mr. Markle was entitled to reply to the People and then publish a whole load of extracts from the letter which do not and are not capable of rebutting the criticisms in People.
Well, I mean, show us as your example, but I expect you're going to take the puppeteering example.
Yes, I think it's fair to say that most of the extracts in italics are...
Yes, I mean, it might be helpful to look again at the People article to see what there was being. The article was responding to, because, as my lady says, the People, the thrust, I mean, I don't want to oversimplify the case, and I don't think the judge did that.
He certainly did.
100 and something paragraphs says he didn't. But it is important to have a proper global view of the case, and we didn't look at much of the People article, only bits of it, and I think it's best to read it.
Yes, well...
Which pages are we on?
Core bundle 377 is where the text starts.
377.
Tab 21, I'm so sorry.
Pages, 377.
Malone and Friends started at 377, and he started with the, I don't know what the correct journalistic word for it is, but the ochre yellow block in the middle of the page at the top contains a reference to Thomas has said she shut him out, claims her friends say are patently false. Just taking that example, the letter, and again, it doesn't have to be true for this exercise. It just has to be capable of either supporting or rebutting the allegation. But the letter, I think I'd better keep one eye on the original of the letter, sorry, the version of the letter that's in the bundle, because not all the important bits or the allegedly responsive bits were included in the article. But the part of, I think it's the first paragraph of the letter. Yes, I'm going.
Where are we best to look at it? In the judge's judgment?
I fear not, my lord. The letter is in the supplementary bundle at 306. It's probably easier to have that. It probably won't be easier for my lord, Master of the Rolls. I'm sorry.
Very easy.
You can jump back and forth.
Incredibly, yes.
What page?
306.
306 of the supplementary.
It'd be easier if we numbering wasn't 30 pages out. But
I'm sorry. It's tab 23.
it's all right. One of your solicitors very kindly asked what they could do to help, and I said it was too late. I've got it, yeah, 306.
I'm grateful. This is actually...
this is not the whole letter.
This is the whole letter.
Oh, it is, is it?
And just for complete accuracy, the passages that are in highlight, bold and underlining are those that were published. So this is a helpful reference point for that which the defendant published.
Yes.
If your lordship will look at the first paragraph, from my phone alone I called you over 20 times and you ignored my calls, leaving me in the days before our wedding worried, confused, shocked and absolutely blindsided. That, far from constituting a rebuttal of what Mr. Markle is upset about on page 377, that supports what the claims of the friends.
Right.
That's
very important too.
I'm so sorry.
That's very important too, to realise that much of what is published is actually simply further support.
Exactly.
Exactly
so. Exactly so.
Rather than a case for
that is the point that the judge was all over.
Yes.
If we move on to the next passage that my learned friend referred to, which is the uncaring daughter one.
Yes.
There is nothing, not only is there nothing in this letter that could constitute a rebuttal of that criticism, but to a large extent, both its underlying premise and a lot of what it says, such as I've only ever loved, protected and defended you, offering whatever financial support I could, worrying about your health, always asking how I could help. So the week of the wedding to hear about you having a heart attack through a tabloid was horrifying. Are there any others? That is probably, for my purposes, good enough as another example of an extract from the letter used in the article, which, far from doing the job that the defendant says it does the opposite, I would submit, or at least undermines it.
But it's the same thing, it supports the article.
Yes.
I'm a caring daughter, and that's
Exactly.
not I'm an uncaring.
Exactly. I'm not sure if it was the very next passage, but on 378 we get into the heart of what it was that was relied on as the pretext. I'll take this. I'd better take this carefully, if I may, because there's a lot of different allegations in here.
Well, we can read it if it's easier rather than you reading it.
Yes.
Is this the paragraph that starts "and while"?
It's top of 378, right-hand column, next long-time friend, the Saturday before the wedding.
Back in the people, yes.
So would you mind just reading that whole paragraph first?
Need to be reading the right paragraph. Long-time friend starting
The Saturday before the
Saturday
wedding.
before, yes. Thank you.
And my lord, going back to the letter at 307, just above the middle of the page is a sentence that starts, "to remember our conversation 7 days before the wedding, when we asked you if the claims of you working with the paparazzi and press were true." Would my lords and my lady just read down to the end of that paragraph?
So you're just going to have to tell me which paragraph that is, a little behind you.
The 307.
Yeah.
There's just above the middle, there's a passage that starts, "to remember our conversation 7 days before the wedding, when we asked you if the claims of you working with the paparazzi and press were true, and told you if we tried to protect you from the story running, something we've never attempted to do for anyone, ourselves included, that we wouldn't be able to use that strength to protect our own children one day. Even knowing that, you said it wasn't true. I believed you, trusted you, and told you I loved you. The next morning the CCTV footage came out. You haven't reached out to me since the week of our wedding." In fact, I ought to read on. "And while you claim you have no way of contacting me, my phone number has remained the same. This you know, no text, no missed calls, no outreach from you, just more global interviews." My lord will see that the latter part of that paragraph was also published by the defendant, although not the bit in the middle which is not highlighted, which finishes just before "I believed you, trusted you, and told you I loved you." But the relevant, what one collects from the passage on 307 is a pretty direct recital of the facts surrounding what, if I can call it, the fake paparazzi lie, all told from the claimant's perspective, none of it reflecting well on the father. What is published, picking it up in the highlighting on 307 at "I believed you, trusted you, and told you I loved you," that's more rebuttal of the uncaring daughter, interwoven with what follows about the CCTV footage, which on her case, and as it happens, accepted by the judge, as it was bound to be. Mr. Markle accepted, he agreed that he had lied, and he apologised for it. So nothing in this letter could possibly have rebutted the passage under "long-time friend" on page 378, because the story of the staged paparazzi photographs and Mr. Markle lying about it was true. It was a true bill for which he apologised. So whilst Mr. Caldecott is entitled to say, picking up on the reference to lying and the way in which the long-time friend tells the story, yes, that doesn't reflect at all well on Mr. Markle. Totally accept that.
The letter doesn't rebut.
No, the problem is it's true, and the letter merely adds more detail. Sorry? Messages where he is apologetic, to be fair to him, and he offers to issue a public apology. But this all comes a few days after the conversation on the eve of the Mail on Sunday Scoop, where they published the story. The claimant and her husband having offered to try to kill the story, and her, the claimant, saying this is a big step for us to take, because if we do it and we're wrong, and we're trying to kill a true story, then we may be losing our own privacy, the privacy of our children. Notwithstanding that, says the claimant, you told us the story wasn't true, and then the CCTV footage came out, so the story was true. And the way it's dealt with by the law...
This is all of a piece, you say.
Yes.
You say nothing in the letter, or, I mean, in a sense it's simple, because the letter comes from it, notionally from the same side of the
Quite.
court.
One shouldn't be surprised.
People, even if it doesn't come from the same physical people, it comes from people with the same views. And so it would be very unlikely that the letter could support the opposing view.
Quite so. Quite
But
so.
I suppose it could be said to be used to support a claim that she was artless because it was, so far from being an olive branch, it was a remonstrative letter.
Yes, my lord. Then at that point we are entering into the bit that the judge took great care over and was scrupulous to analyse.
Which was the complaint about the press.
Well, it was the. Sorry, I've not been clear. The judge was prepared in the defendant's favour to accept that the letter could have been deployed to rebut the olive branch allegation. It doesn't matter. I don't think this court needs to rule on our rival's submissions about whether it's defamatory or an attack on Mr. Markle. The point is, both sides agree it was untrue, that there was a mischaracterisation of the letter.
That it was not an olive branch.
Exactly.
Yeah.
And so the bit that on the defendant's account Mr. Markle got so worked up about, and which is the foundation upon which this entire edifice is based, is the words, "so we can repair our relationship," 378. I said it was 24 or 25 words. The word count starts at "Dad, I'm so heartbroken, I love you, I have one father, please stop victimising me through the media so we can repair our relationship," close quotes. Now, as I say, that was the trigger or the pretext for the defendant's publication, and it's there in the article. It's a strand in the article, and one finds it in the block text underneath the first article on does my lord have the A3 copies, which have the revealed the letter showing true tragedy of Meghan's rift with the father. This is the first of the articles sooner. And in the subheadline in block text, how Meghan's media fightback led her dad to reveal letter he wanted to keep secret, one finds this quotation in the third column from Mr. Markle. "The letter was presented in a way that vilified me and wasn't true," he said last night. "It was presented as her reaching out and writing a loving letter in the hope of healing the rift. But the letter isn't like that at all. Meghan can't have it both ways. She can't use the press to get her message across but hang me out to dry." Will your lordship please note the start of that quote, "The letter was presented." The letter was presented in People magazine. That is the focus of Mr. Markle's grievance. And my lord is quite right to say that that is where the judge was very careful, we would say, to give proper weight to the question of how might Mr. Markle, through the defendant, rebut that inaccuracy. It doesn't matter for present purposes whether it's true or not.
Just give me the paragraph.
Of the judgment?
Yes, please.
Yes. His conclusion starts at 1, 2, 3. he deals with the handwriting article very, very, one might say dismissively at 122. But at 123 he deals with what he regards as the material inaccuracy of the People's article's account of the letter. Perhaps I could just ask the court to read down to the end of 1255. To spare having to listen to my voice.
The real guts of it is at the end of 124. Proof of this is that the Mail articles do not use the letter as evidence that Mr. Markle was innocent of victimisation. Instead, they set out the parts of the letter which show this was an aspect of the claimant's criticism.
Exactly.
They seek to rebut it by quoting Mr. Markle.
Yes.
So the letter is used as a vehicle rather than actually being a rebuttal at all.
If I was being cynical, my lord, I would say it was obvious that the defendant was regaling its reading public with sensational extracts from a long letter, and along the way allowing Mr. Markle the opportunity to critique the criticisms it contains. So it's happily riding both horses and selling a lot of newspapers.
And so when he says necessary or proportionate, as you said before, it's really justified for the reasons he's given before.
Quite so.
And it could have been achieved by proportionately by publishing a rebuttal consisting of a summary, which is what I said. In fact, you don't need this all the blue bit. Well, no, I'm sorry, it's not helpful with blue
Well, my lord is quite right to ask that question, because the extract on, I don't know if you're using a numbered version, but
yeah.
It's page 5 of the internal Mail on Sunday number at the top right hand corner. Do you have the first article, the True Tragedy article? On the right hand side of my A3 spread, one has the heading, the bottom of the block of extracts, "Come out of rabbit hole. If you love me as you tell the press you do, please stop. Please allow us to live our lives in peace. Please stop lying. Please stop creating so much pain. Please stop exploiting my relationship with my husband. I realise you've so far down this rabbit hole you feel there's no way out, but if you take a moment to pause, I think you'll see that being entered with a clear conscience is more valuable than any payment in the world." That is what the judge describes at the paragraph that the law just referred to as paragraph 15 of the letter. And if one looks at 125 subparagraph 4, do you see he concludes, he makes a rebuttal point.
That it was legitimate to disclose paragraph 15.
For this purpose to disclose paragraph 15. Now, my lord, nothing turns on this, but a point that we made, which doesn't, I think, find its way into his judgment, is that even the way the defendant deployed this paragraph was unfair, because what they left out were the closing words of the letter. "I ask for nothing more than peace, and I wish the same for you." It doesn't perhaps make any difference, given the conclusion the judge made in any event. But what I should take attention to is what he says about the 127. It's really a belt and braces. But they didn't even deploy paragraph 15 as a rebuttal of the olive branch. It's just there with the rabbit hole headline. And such a rebuttal as one finds is on an entirely different subject.
It's about the use of an American using the word rabbit.
Exactly.
Yes.
So again, it's false flag, and it's cynical. As my Lord has said, the article in the body of the text does, at some length, and I would say with a reasonable degree of conviction and detail, afford Mr. Markle his right of correction on the olive branch point. There's the reference I already took you to under the subheadline, and then there's the various passages in the text. For example, paragraph 11. I thought it would be an olive branch. He said it was a dagger to the heart, Mr. Markle said last night. Now, I don't, for the avoidance of doubt, I don't say that the defendant should have confined itself to giving Mr. Markle the microphone, so to speak, to rebut this or correct this false characterization of the olive branch. They could have deployed some of the text of the letter. It doesn't even matter, perhaps, whether or not one agrees that it's paragraph 15, although the respectable Justice Walker, I submit, is absolutely right. That would be the perfect quote to use. What matters is that on any view, what's being deployed is excessive, not germane, not logically capable of rebutting the people up to it. And that's before we get to the precipitous.
Yes.
Well, I think I was sort of in the middle of the People article. Could I just quickly finish off on that? If we go back to 378.
Well, we read the right-hand column, long time frame.
Yes. And then if you could just read on to the photo op.
Where is the photo?
This is about 7 lines up from the bottom of the right-hand column on 378.
Oh, yeah.
He writes her a really long letter in return, and he closes it by requesting the photo op with, she feels like that's the opposite of what I'm saying. I'm telling you I don't want to communicate through the media, and you're asking me to communicate through the media. Did you hear anything I said? It's almost like their ships are passing. He knows how to get in touch with her. Her telephone number hasn't changed. She's never called. He's never texted. That encapsulates 2 points, or 2 criticisms, if I can put it that way. There is the photo op criticism, ships passing in the night, and then there's the complaint that he's never called, he's never texted. Dealing with the latter first, I think I've already taken you to material in the letter, which is to precisely the same effect. So again, same point applies. Nothing in the letter that could serve to rebut that.
Well, and the whole letter is about, is complaining about the kind of thing that the photo op reflects.
Yes, it's the gist of the complaint is stop going to the press. And then I offer nothing other than peace, but stop going to the press. She's not actually closing down her relationship with her father, but she's making it clear, please stop talking to the press.
So is there anything apart from the olive branch nature that the judge accepted did allow the letter to be used?
No, and the learned friend has a criticism of the photo op point, and I hope I'm not mischaracterizing it, by saying that he says, well, you need to look at the characterization of the letter and the added, as it were, criticism about what comes back in reply, the photo. And the learned friend would no doubt say that the criticism about the photo is sharpened or made worse by what precedes it. And I accept that's a fair point, but only up to it. The real question is, how could anything in the letter have served to further Mr. Markle's purpose in rebutting the people? The problem for the learned friend is that, again, as the judge rightly found, the photo op charge was a true bill. He quotes from the, one may remember that the article actually quotes from the reply, from the father's reply. It quotes the bit about requesting a photo. Why can't you just fake it? And the judge, we submit, was entirely right to say that nothing from the letter could make that point any better for Mr. Markle's point. And the reference to that Mr. Miller, as ever, is yes, it's 114 to 115. The key bit is the beginning of 115. Ending with, I am unable to detect in these paragraphs any logical or arguably sufficient basis for disclosing any part of the letter. And just so your Lordship has the reference, it's the second of the articles. Meghan, stop painful attacks on Harry. Right-hand side of the A3 spread under you can hate me if you want, where the extract from Mr. Markle's reply is set out, self-evidently with Mr. Markle's blessing. What the point the judge makes is entirely right. He can't complain about equal articles' characterization. He may not like it, but it's an entirely reasonable characterization of his reply. Lord, I'm just looking at the time. The one.
Well, it would suit me anyway if we were to break a little early tonight. How are we doing for them?
I'm confident we'll be within our collectively agreed time, so I should be about halfway.
We will do that, and we'll resume at 10:30 in the morning. Thank you.